Her net income is 58,501 as per the finding of the court bill itself. And your income 1,62,000. 60,000 for the child. But the amount of alimony directed 50,000 is exorbitant.
No,
You
but
are earning
that
58,000 per month. That is a child of the marriage. Yes.
And immediately, as usual tactics adopted the parliament is the law. She is the wife. She filed an application to alimony. Your lordship is aware of the provision of law regarding section 36. You can get alimony.
Her net income is 58,501 as per the finding of the court bill itself. And your income 1,62,000. Is any breakup given in the application for alimony? What is the amount sought for her child?
At first, it was sought for my application 35,000 and suddenly he increased it, paying for 60,000.
Increased how?
Taken out an application.
Application for what? Addition of part amendment. 60,000 for the child. What is the expenditure she shows for a child? It's 50,501. What do you do, Mr. Bose, your client?
I'm working as price photos and photos. I'm a manager over there, and I have disclosed my income with all the proofs of income and every document.
I want to see the affidavit of the wife regarding her child's expenses.
I provide the way.
50,000. Why 50,000, Mr.
Well,
Go? You are earning
I'll just
58
indicate,
lakh,
well,
12,000.
I'll just indicate I have just got a chart. That
Give a
has been
copy
pre-
to him.
Yes, yes, definitely. Sir, this is a chart that I have received from my client. If my lord kindly considers this chart, in terms of the order, it has been directed to pay 50,000. However, in spite of the order, my learned senior friend's client has not been paying that. And
Mr. Go, whatever are the arrears, you are entitled to recover by execution. We are
my
not
lord, we are not
execution is concerned with that.
pending.
Yes, that will take its own course. But
Yes.
regarding the amount of alimony directed, 50,000 is exorbitant.
No, my
You are
lord,
earning
that
58,000 per
includes-
month.
Now, my lord, I'll just indicate I have further
For
taken
your
this
son, we can consider, but for you,
for
nothing is.
son,
Yes.
the total expenses as I have got instruction is close to 56,000.
But we get that. You must have disclosed in your affidavit of assets in the
my
court
lord,
below.
that
Shows
has
that.
been
Certain statements like enjoying birthday party, everything.
no.
No,
my lord,
take your
that
seat,
is
Mr.
not,
Bose.
my lord, the school's fees are there.
58,000 is sufficient income. You have sufficient income to maintain yourself.
My lord, to
Not
an
just
extent,
because
my-
he's earning more does not mean that he'll have
my
to
lord,
pay.
at the
For the
same time,
son also you have to share because both the parents are earning.
yes,
So both of you have to share. It will be proportionate to your income. So
exactly.
it will
Now, my
be
lord,
yes.
my income, admittedly, as I have provided in the chart, is as on date is 60,000 per month. My income
58,000 something. Yes.
58,060. My
One
learned
lakh
friend's
26,
client
yes.
is 2,09,000
No,
income.
trial court's finding is 1,62,000.
But my lord, as per my instruction, it is 2 lakh.
Salary.
That is
You have
the
not
gross.
preferred any revision, Mr. Guho. Please come to page 2 of the impugned order.
Yes, ma'am.
Your salary slip. Sorry. Please come to page para 10 of the impugned order.
Yes, ma'am.
Now, salary slip shows this is the finding. This is not challenged by you.
No.
You earn 58
Yes.
minus son expenditure of about 56,000.
Correct.
We'll look into that.
Yeah.
Before that, the income of respondent is 1,62,000. Joint income of the parties per mensem is such and such from jointly owned flat, which he denies. But we are not much on that because if you say it's a joint income, then your incomes cancel out each
Well,
other.
joint income, perhaps the learned trial court wanted this 2,20,000 wanted to add up 162 and 58, and then came to this joint income.
No, from the flat.
No, my lord, joint income of the parties
Ah, sir.
is rupees 2,20,000 plus 18,000 rent.
Rent from jointly owned flat.
income.
So if the
that brings up to 230.
18,000 rent from jointly owned flat, I am discounting because your income's jointly owned, so cancel out each other. We are.
But I am not receiving that thing. That is not my instruction that I have been receiving that.
There's no. Did you prove any? Give you any proof that he's earning or there is a rented accommodation?
My lord,
He's saying it's vacant.
Apart from the instruction that I have got, if my lord says I can put in a very short affidavit.
No, in revision we won't permit you. Whatever
But-
was before the court will.
But my lord, what is my instruction is that my learned friend's client, that is the husband, has a rental income of 18,000.
Instruction
the-
won't do, Mr. Guho.
Then,
If
my
it
lord,
was not before the court below, we cannot know. We don't find any evidence being relied on by the trial court regarding the rental income. So we have to proceed on 1,62,000 and 58. I am proceeding on that premise. But then,
Yes.
if you are earning 58 lakh, it's not that if you whatever your husband earns, it has to be equalized with you. The test is whether you have got sufficient income to maintain yourself.
to an extent, 60 is
58,000
concerned, 60 is mine. But, my lord, kindly
for
appreciate
the
this.
son, yes, definitely.
There has been no payment till date. That is what
No,
I
for the
wanted.
son, we'll consider.
Yes.
Mr. Bose, this is not a COVID lottery sort of thing going on. Please take your seat.
My lord, what
Yes,
I
Mr.
understand, if my lord kindly, because I'll try and satisfy on my lord's queries, but what instruction that I have got is in the year 2023, only once the husband has paid
Bro,
79,400.
I'm telling you, we are not bothered with that much
Very
now
very
because you are entitled to execution and you have levied execution. Quite rightly, you can get an order there. Whatever you can get in attachment even or send him to jail.
Yes.
We'll do that. But about this 50,000, this is without
But
any basis. There is no material
50,000
basis.
is only for the son, my lord, and me. That is what it has
No
come to.
quantification. It has been stated. I do hold that an amount of 50,000 per month as maintenance. On what basis? 25,000 litigation cost.
Perhaps the trial court tried to.
We cannot look into the mind of the trial court, Mr.
Well,
Go.
But my lord, when the son's expenses is 56,000,
Show us that from your affidavit of asset.
my lord, that is the recording in the order itself.
We won't go by that. That is
Then, my lord,
precisely what
kindly
has been challenged.
grant me one opportunity, keeps it next Friday.
No,
let
no,
me come back
I
to-
want to see everything has
from
been
records only. From records only. If
Show me from the records right now. Why next week? St. James School, you have annexed the school fees and all.
Definitely. My lord.
He's 14 years old,
12 years.
12 years. So about class 6, 7 maybe.
Yes. So, my lord, that page,
This is of class 2.
page 132, my learned friend,
Yes.
senior friends, has only enclosed his class 1 and 2.
Yes, but
This
he
is-
has
these are
enclosed
all
your
old.
enclosures.
These are all old. 2019.
What did you produce?
My lord, that I have to check, my lord. Currently, immediately, I don't have that thing
But
readily
nothing is
available.
disclosed in the impugned order. The judge, learned judge, all on a sudden says yes.
No, my lord, definitely after considering the affidavits has
Yes, but
only
what is the
done-
ratio? What is the ratio? We cannot look into the mind of a judge.
Definitely, my
The
lord.
reasons have to be reflected in the order. The order says he earns 1,62,000, you earn 58,501, joint income 18,000, total earnings such and such in the light, keeping in view the liabilities and heads of expenditure. Now, I am not even looking into his expenditure for his uncle, aunt, all those things. We are not looking into that. Definitely not. Because even if he had that uncle and aunt, he had to maintain you and his son.
Absolutely.
But 50,000, there is no basis to this.
My lord, 50,000
For the
what I-
son, I can appreciate some amount is necessary. Yes. You also have to share some amount because you are also earning.
Kindly see, my income as on date is 60,000. Now, I have been maintaining my son all along. Unless August 2024, my learned
When did you
friends-
file the application for alimony? It has
My
been
lord,
granted
this-
from the date
this
of
is in
alimony.
2019, this
No,
application for maintenance.
No,
26 November.
it has been granted
2019.
from the date of the the
Yes,
application.
Yes.
So I'll maintain that. And it has to be from the date of the application.
Correct. So 26 November 2019, I have.
Whenever you filed the application for alimony. But at best for the son, we can grant 25,000, half of this. Why 50,000?
Well, let me bring on record the affidavit that has been filed, if that is not, because I don't find it in the revisional application.
You haven't annexed the affidavit filed by the wife.
My lord, I have annexed. If you lost
Which page?
if you lost once takes the trouble to look at page 139, I'm continuing paying 25,000.
We are not interested. I'm asking you a specific question. Show me the affidavit of asset filed by the wife in the court below. You must have annexed that. You cannot suppress that.
My lord, so there is a chart that has been, perhaps my lord will find
You
the
have given a chart to me.
my lord, my client only.
These
This-
charts were before the court below.
Yes, my lord, because this contains the 56,536.
No. We can't rely on chart. We have.
Breakup is there.
I want to look at your affidavit in opposition. The affidavit of asset.
However, my lord, the
You are not
breakup-
prepared on that. You have got a copy of the revisional application. You knew the application is appearing in the list. You should have taken it from your client. The court would. That is the first thing the court would ask for. Your affidavit of asset in the court will.
Just give me.
From the order, I don't find any premise, any reasoning. Only your cases have been reflected, and yes, there is a finding regarding your respective incomes. But this I do hold has no
Yes.
premise, no reasoning. Why 50,000? You are earning 58,000 yourself.
But my lord, my entire money is going to maintain my son. Then how will I maintain myself?
58,000 cannot spend for a
Because my
6-year-old son, 12-year-old son. You cannot spend
my lord, that is
58,000
the breakup
per
is
month.
given before the
That's
court
an
below.
inflated breakup.
That is the breakup that has been given.
Show me the affidavit of asset.
My lord, this is a
Neither of you are ready with your affidavit of asset.
my lord, may I
I
just
suppose
hand
you
up-
should have annexed.
my lord, may I just hand up this affidavit?
This is
This
an
has been
affidavit of asset filed in the court
No,
below.
my lord, this is affidavit in chief, not the affidavit of assets.
That won't do.
I understand.
Rajanish versus Neha is for that purpose only. That judgment.
No, my lord, this is not the affidavit in
Mr. Go, I'll set aside this order. I'll in the
my lord,
meantime.
may I just
No, I'll
receive-
remand it. I'll remand it, and that I'll direct the learned trial judge to decide within on the materials on record to assess on the basis of the affidavits of assets of the parties and reflect that has to be reflected in the order. And regarding this 50,000, in the meantime, till disposal of that, I'll fix a time limit. Till disposal, only 25,000 for your son for the
My lord,
time being ad hoc.
may I beseech one thing, my lord? My lord, what I understand, my lord, maybe currently I'm not having the affidavit of asset. That is my lacuna. But my lord, give me one opportunity till next Friday. If the affidavit of asset is there, let me bring it before the
Very
court.
good. Very good.
Because since the court has come to the exact finding and I am having the breakup on my hand. So, my lord, this exact finding of 56,536 that is there with me. So
Bring
must have
a
been,
copy
it
of
has
your
been
affidavit of
filed.
asset. Yes.
Allow me to bring it, my lord.
The present revisional application has been preferred against an order whereby